Yeah. Uh, Today's lecture is on torts. Torts are wrongs that are actionable. Actionable means that you can bring an action in court. That is, you can file a lawsuit against somebody if they've committed a tort, which is a wrong, a personal wrong to you. And so, in this sense, we're talking about wrongs that are not criminal wrongs, but we're talking about wrongs that are considered to be torts for which you can sue another individual. If he, for instance, punches you, that would be the tort of battery. And so before we actually get into talking about these various torts, we need to first maybe talk about the trial process. So a trial begins when there is usually a dispute of some sort. The dispute might be a dispute over a contract. So you could have a lawsuit over a contract, whether or not somebody had fulfilled his obligations that he had promised you to do in his contract with you. So that's one kind of trial. But what we're interested in is trials that involve either an injury, a physical injury maybe, or maybe nowadays an emotional injury, which were not something that you could sue for back in the, England, and under the common law of England, you couldn't sue for injury. You couldn't sue for an emotional injury even up until the middle of, say, even after the middle of, maybe until the 60s, 1960s. You could not bring a lawsuit for intentional infliction of emotional distress, for instance, or negligent infliction of emotional distress, which you can now do. You could get some recognition of emotional damages for something like defamation, where, basically, or other kinds of emotional injuries might be actionable if there was an actual physical injury besides that. So, we'll talk about that later as we talk about damages. So, basically, it's a trial process can begin where there's a dispute, or if there is a injury or a loss. Could be a loss of money, could be a damage to your property. For injuries and losses, financial losses of whatever sort, you could bring a case in tort usually. And so we'll talk eventually about the various kinds of torts, but let's talk a little more about this trial process. It starts off with filings. The filings are basically one or two sorts. A plaintiff will file a complaint. So for example, let's say that Paul sues Pam for battery. That is, he claims that she hit him physically, punched him, and that she actually broke his jaw, which is rather unusual because ordinarily you cannot punch somebody in the face or on the jaw and break their jaw. Jaws are usually much more durable than that, but some people might have what's called a glass jaw. This would be a jaw that had been previously injured. And unfortunately, if you happen to commit the tort of battery against a person with a glass jaw, you would be responsible for the harm that you did to him. And so, you might have a defense. So what would your defense maybe be? Well, you would maybe have a defense, let's say that Pam says that she punched him because he was threatening her with a gun. So, she was acting therefore in self-defense, which is an affirmative defense that she can reply. So he'll file a complaint, and he alleges in his complaint certain facts. He has to allege facts that amount to a battery. So it has to be an allegation in which he claims that she had taken some offensive action against him, and that had caused him physical injury. In this case, she had broken his jaw, and he wants to be compensated for that. And in his complaint, he will claim maybe some sort of damages, some amount of damages. Let's say he claims $100,000 for this broken jaw that he received. Okay. Now, will he get $100,000? That kind of depends. That would be a fact that would be disputed. So she can contest all of his facts. One way she could answer the complaint is to deny that she hit him. She could deny that he had an injury. She could deny that the injury was something that she should compensate him up to $100,000. So he's going to have to prove all the facts of his allegations if he wants to win. So he needs to be prepared to do that. And in fact, if she thinks he can't establish a case, she could even file a motion for summary judgment. We'll talk about that in a minute. She hit him because he was threatening her with a gun. That's a perfectly good defense. You can defend yourself, and but she'll have to prove that allegation. So that's an affirmative defense, which actually would be also possibly a countercharge. So she would be countercharging him with assault, which is another tort. So her defense in this case is not merely a denial, but it's more than that. It's also a counter complaint. So she's filing an answer that's also a counter complaint in which she's alleging that he has committed a tort against her, which is the tort of assault, which is compensable also. And she will also ask for damages to him. Let's say she asks for $10,000, a lot less than $100,000, but she's perhaps has to prove how much damages she had. So she's going to have to prove that she was caused emotional distress maybe by this. And you could, in this case, nowadays get damages for emotional distress in assault. As a matter of fact, even under common law, you could have gotten paid for the distress that you would have, the emotional character of that. So, you know, that you could actually get under the tort of assault. And so that would be her answer, and she's going to have to prove that he did point a gun at her, and therefore that she thought that she has to prove that she had a reasonable apprehension of fear in pointing a gun at somebody. Probably that's going to be enough for her to allege that. If the jury believes her that he did point a gun at her, if her testimony is taken, it's helpful if you actually have more than one witness. But if you don't have one witness, you can still win on your own testimony. So very important to be able to produce the evidence. And she'll have to also prove that whatever the extent of harm she had. So she could, you know, maybe show that she went to a psychiatrist to talk about the fear that she had. She's been having recurrent nightmares about guns and things like that. She could produce these as evidence of the damage that she had received in terms of the assault. But she's got to prove her allegations. Okay, and if she proves the allegation of defense, that would be a complete defense, I think, that would cancel out his claim for a battery against her. So, these are the filings. There's a complaint and an answer. And an answer can also constitute a counter complaint. And of course, he could answer her counter complaint by, you know, denying it. That's most or, you know, maybe some other sort of affirmative defense that he might have. He pointed a gun at her because she threatened to punch him, and so he was actually pointing a gun at her in self-defense. So it can be very complicated that way. I mean, you can be charges and counter-charges. But whatever charges you make, you're going to have to put on proof of it. Some proof could be testimony. And it's all going to get down to who's credible, who does the jury believe, who does the judge believe in some instances, if you're going for summary judgment. So after the complaint is filed, the complainant has to send notice to the other side about the complaint. So that means he must print out the copy of his complaint and send a copy to the defendant, who then gets that complaint. And so he has to, on his complaint, note that he has sent a complaint to the other side. So the judge doesn't have to send that complaint. It's actually sent by the attorney for the plaintiff. And so that's just done standardly. And, you know, and so he's all these filings are with the court. And so both sides know. And when you file the complaint, then the court will set a date on which they would actually have to do that. So the rules establish that after receiving a complaint, the person has maybe 30 days, maybe 60 days to file a counterclaim, and you know, an answer. Anyway, after these filings are made, so the next stage is one where motions are made. There are various kinds of motions that can be made. We'll talk about a few of them here. One very important motion that is always made nowadays is a motion for discoveries. What kinds of discoveries are we talking about? Well, we're talking about various kinds of discoveries. There's also motions for summary judgment. We'll talk about those too. So let's talk first about discovery. A very basic kind of discovery is interrogatories. Interrogatories are questions that you send to the other side that he must answer. If he doesn't answer, you can file a motion to compel him to answer the questions. So why do we have discovery? Interrogatories is one form of this discovery process. We allow discovery because it quickens the process. It's more efficient. Each side gets to know what the other side case is, and once they know what the other side's case is, what kind of witnesses, so one of the questions you would ask in interrogatories, what witnesses do you have? And you would ask for whatever other evidence you might have that proves your allegations. So you asked all these questions. What evidence do you have showing that you are entitled to, say, $100,000 or $10,000? You know, whatever you're claiming, you're going to have some evidence to prove it. It may be testimony of a witness, or it might be other physical evidence, and we'll talk about how you can recover all this and get all this before the trial begins. Each side is going to know what the other side's case is and how strong it is. So what kinds of discoveries do we have besides interrogatories, which are just simply questions that have to be answered? There's a request for admissions, and these would be things that he admits. Does he admit to having struck her? Does he admit, does he admit, does she admit to having, struck him? Does he admit to, each side will be exchanging interrogatories in this case. Does he admit to having, pointed a gun at her? And does he admit the gun was loaded? Does he admit the gun was of a certain type? Was it a Luger, or was it this kind of a gun or that kind of a gun? Or is he going to claim it was a toy gun, okay, which would put a different picture on it? Was it a noticeably toy gun? Well, if it is a gun, there might also be a request, a subpoena to bring in the gun, a request for the production of the item itself, the artifact, in this case a gun, so it can be examined, so that he will be able to examine, she would be able to examine the gun that was pointed at her, and she would be able to take a picture of it, and that and it could be also produced at trial, so you can subpoena that gun to be brought in. You can also have a request for documents. In some cases, there might be documents that you want to have introduced. Not so much in this case, perhaps, but in some cases you might want letters. So, for instance, in a divorce, maybe there's a letter. In one case in Indiana, there was a letter that was sent by the man's mother to a letter that was sent between the man and his mother, and there was a request for the documentation of that letter, because in the letter he had pointed out, I'm sorry, no, it was a letter from her to his mother, and in that letter she had admitted to agreeing to certain settlement of property issues as to who would get what. Who would get the car, who would get the truck, who would get the farm, who would get the furniture, who would get this and that, and the next thing, who would get the dog. These kind of things were written down in a letter and sent to his mother. And his mother didn't have a copy, but she remembered having gotten it, so she asked for a copy of the letter and that the other lady had, and so they were able to recover it that way. So a request for documents in some cases is going to be made. There's also a request. You can also make a request for depositions. You can require the person. You can depose witnesses that he has. You can depose the defendant. You can depose the plaintiff. All the parties are subject to being deposed. Deposed means that they come in for questioning, and they're put on, as if in trial, they're put on, they're asked questions as if they're taking the stand and doing that. They're sworn in, and there's usually a court reporter there that records their answers. There can be objections to questions. If the question is not relevant or material, they can object to it, and they need to make those objections during the deposition. Now, the reason for the deposition is to firm up the testimony so that each side knows what the other side is going to testify to. Also, the attorneys get a feel for how strong a witness is. Is he a strong witness? Is he a witness who testifies with confidence? Is he a witness who doesn't hesitate? Does he seem to be telling the truth, or does he look shifty, or so you get a feel for maybe how strong the witness testimony is. So the whole ideal is, behind allowing discovery, is that each side gets to know how strong the other side's case is. That makes it possible maybe they can settle the case. Both sides get an idea of how strong each other's case is, and therefore they could maybe settle this and not have to go through a trial, saving the state the money of a trial. The state has to provide a courtroom. The state has to provide a recorder, and has to require, usually you have to have a judge and clerks who work for the judge. The bailiff these are all money that are being paid by the state for the trial. Now, when you file a claim in court, you do pay a court fee, but that court fee in no way pays all the expenses of that trial. And now the side who loses the case can be made to pay, in most states, the side who loses can be made to pay court costs. And this includes sometimes the cost of the other side's attorney if they lose. So you don't necessarily want to bring a case to lose it. So unless you're confident that you can win, you probably don't want to necessarily bring a case. You'll be maybe spending money on your attorney and not necessarily get anything back. Other than that, if the court rules don't allow for recovery of the fees of the attorneys, each side will pay maybe their attorney's fees. So traditionally, each side paid for their own attorney. That has somewhat changed modern litigation, oftentimes, as in cases alleging discrimination brought against an employer. The employer, if he loses, will usually be made to pay the fees of the attorney for the complainant. That is, the person claiming that they were sexually harassed or they were discriminated on account of their race or whatever the charge is. If they can win the case, then the lawyer will be paid by the employer. Now, most people would maybe not bring these cases if it was otherwise, right? Because they would look at how much it might cost to pay an attorney to bring a case. They don't know whether they're going to win or not, and they would be hesitant to bring a case. But if the attorney says that he would collect from the other side and he's confident that they can win, then they don't have anything to worry about. So anyway, the discovery phase basically promotes speedy resolution of these cases. Motion to compel, although some information is not discoverable, there are certain questions you cannot ask. For instance, if you want to ask for $100,000, what makes you think the person has $100,000? Well, it'd be nice if you knew what his salary was, right? So you could request, you would maybe like to know what kind of money he makes, so can you ask for his tax return? And the tax return would say how much money he made. Can you ask for what his income is? In most cases, you cannot ask for that kind of personal information. You certainly cannot get his tax form, which is not largely irrelevant to the case. And refusal. So there are sometimes you can refuse to give certain information if it's an invasion of privacy and doesn't really promote any issue. Maybe it's not relevant, maybe it's not material, and therefore you're not necessarily entitled to get it in discovery, as you wouldn't be able to get somebody to testify at a trial. Anyway, after the motion phase is over, after the parties have made their motions, and usually that may take some time. So you have, first off, you have the filing of the case, and then the one side has maybe a month or two to respond to the filing. In most cases, I think it's usually 2 months that they have to answer, and so you might after that have some delay as each side goes through discovery, as they're each given time to do these depositions. So these have to be scheduled, and so each side either side can delay these kind of proceedings by dragging out the time for depositions. Deposition to take time itself. And so after all this is done, you can also go through what's called jury selection. So jury selection, all courts will have a jury pool, and they will populate that pool from a list of people. Sometimes they use the list of voters. So a very popular thing was to have people who were voters, their names, the court would have a record of who votes, and those names could be used to draw jurors from. Or you could draw it from the tax list. So they usually have some list of people in that particular jury district, and they can usually draw from that list people who would be available for, and all citizens are required to go to jury trial. If you do not respond to being summoned to a jury, the judge can send out a contempt of court order against you and have you brought in, and you'll have to answer why you didn't show up. So you will show up. If you have an employer who tells you you cannot go and do jury duty, you need to tell the judge that your employer has threatened you with being fired if you went down to do jury duty, and the judge will send him a contempt of court. And if he then interferes with your doing jury duty, takes any action against you, retaliates against you, or whatever, the judge will deal with him and maybe fine him, or maybe cause him to have a brief stay in jail. So the judge has power of contempt. They can put people in jail, they can fine people with the power of contempt. And so jury selection. Now, jury selection starts off with what's called voir dire. Voir dire is where the jurors are sworn in and they're told they need to respond to the trial. Before they actually sit in and for the voir dire, they're usually required to fill out, and in most courtrooms, as a matter of efficiency, they will require jurors to fill out certain information forms. This information forms gives general information, which might be things that would otherwise be asked by the attorneys in voir dire. So the attorneys in voir dire can ask questions to determine whether or not a person can be denied as a juror on account of cause, or whether they, in some cases, they may decide to exercise what are called peremptory challenges. So you can challenge any juror on account of cause if you can show there's a reason to believe that he would not be fair in voting. So for instance, if I had a client and he was accused of being drunk, I would want to ask the jurors did they believe that drunks were criminals? Did they believe that drunks were sinners? Did they believe drunks were bad people? I would want to ask them that. If they answered that, if they thought that, I'd want to ask them if they thought drinking one glass of water or a beer or a glass of wine, is that a sin? Is that a bad thing to do? I would ask them those questions. If they answered yes, I'd ask them to be removed as a juror because they have a negative belief and are prejudiced against my client who was accused of being a drunk. Possibly, I have no doubt that the prosecution can make a case that the man had been drinking. Then the question is, was he actually drunk when he was arrested? That's a different issue entirely. So I would ask him that. Other things that, the prosecutions used to ask black jurors, especially black jurors, but in a death case they would ask almost all jurors whether they believed in the imposition of the death penalty. And black jurors and blacks in general were known to be opposed to the death penalty. And they even nowadays can ask them that question. If a black juror says he's opposed to the death penalty, he will be dismissed from the case for a cause. Same if a white juror would do the same. However, there was a time in which the prosecutors would just simply routinely dismiss under peremptory challenges black jurors in death penalty cases and ask for cause because they would show statistics showing that blacks as a group generally do not approve of the death penalty. And so in voir dire, the attorneys and the judge get to ask questions of the jurors, and they can dismiss jurors based upon those questions if those questions indicate a kind of prejudice. On the other hand, a and almost all jurisdictions give to the attorneys on both sides peremptory challenges. Maybe there's 6 peremptory challenges. There could be more, there could be less, could be 3, could be 9, could be any number that the jurisdiction sets up. 6 is maybe fairly common, 3 is fairly common. But on these peremptory challenges, they can dismiss a person without giving a reason. So they'll ask questions, and depending upon the person's answer, they may dismiss them for that. So one question that I used to like to ask was whether or not how much education they had. Now this was oftentimes something that would be actually on the information form. And if I had a particularly well-educated juror, I wanted him to be on a case where I was defending somebody who was charged with a criminal action, because I knew that the more education a person has, the more easily it is to persuade that there is a reasonable doubt that the man committed the crime. So one thing that higher education does is teaches people to be more critical in their thinking, meaning that they're more likely to find reason not to believe that something that a person of authority is saying. So I wanted more educated people on the jury as a defense attorney. So that, I did that on the basis of statistics. Other jurors might do it on the basis of what we call the seat of their pants. They're experienced trial attorneys, and they believe they can determine whether or not a certain kind of jury is going to be favorable to them. So in the O.J. trial, in her book, the attorney who prosecuted O.J. Simpson said that she had allowed the black jurors on the jury, the black women on the jury, because she believed that they would favor her side of the case. This was done on the seat of her pants. There was a professional jury selection firm that would help one pick a jury, and they had done actually a survey of black women jurors in the O.J. case and offered this information free to the Los Angeles prosecutors, but they refused to take it. Instead, they went by the seat of their pants. Well, their information said that black jurors were not going to favor O.J., a black man, over his wife. No, actually, it said that their information said that the black jurors, female black jurors, would favor O.J. over his white wife because they saw her as being one of these vicious white women that had taken one of their really eligible young bachelors away from a black woman. And so they were actually, in favor of O.J. and likely be biased in his favor. And so that was what their point of view was. And it turned out, in fact, that black female jurors were very vociferous and strongly for O.J.'s defense against this white woman. And even though there was evidence that he had previously beaten his previous black wife, and so the attitudes can be different. So, obviously, if you can afford to hire those people to advise you on your jury selection, you have an advantage as opposed to somebody else who's doing it on a basis of maybe a statistic, which is a little bit better, or on the basis of their experience thinking that they can persuade people to see it their way because of previous cases that they had. So jury selection is a very important kind of thing. I always use all my peremptory challenges. If I get 6 challenges, I'm going to use them. And I'm going to use statistics to determine who I want on there. But there were certain things that were sort of seat of the pants that I also adopted because it was backed up by statistics. I would eliminate from a defense, if I had a defendant accused with any sort of a crime, I would eliminate from the jury any juror who walked into the jury box carrying a Bible, on the ideal that people who are that strongly religious that they would carry the Bible into the courtroom around with them are likely to be ones you don't want to be on there. I would eliminate from the jury panel people who worked in some form of law enforcement, even a person who was maybe working as a security guard at Walmart or in some store. I would not want them sitting on the panel on the ideal that statistically they are likely to favor the prosecution. You know, that they develop attitudes that are that way. I had one case in which I removed from the jury a woman who upon questioning, I found out to be the wife of the prosecutor. Obviously, I asked the jury, the judge to remove her for cause, and he did. I didn't need to use the peremptory challenge in that instance. I said, she's his wife. I don't think that we need her on the jury. It's not going to be a good thing. She's in a difficult position. She can't judge him fairly. Anyway, so voir dire is a very important part of winning a case. There's things like that. For instance, if you had a defendant who has pronounced German accent, you might want to eliminate people who are Jewish and have a negative reaction to the ideal that Jews were killed in German prison camps during the war. In other words, that might be something that they might see him as being a Nazi because he has what appears to be a German accent. There was a whole trial in regard in which the person, it was Dr. von Bülow, was married to a rich heiress, and his wife had diabetes and she took insulin, and one day she died from an overdose of insulin. And her son thought that Dr. von Bülow was responsible for her death. He says, the man's a doctor and she dies from taking an overdose of things. And he thought that the man had killed his mother. And of course there was a lot of money at stake there. He also stood to inherit a lot more money if the will was thrown out. And it would have been if he would have been convicted of killing her, because he was receiving money under the will that would have otherwise gone to the children. And so this thing was tried, and in the first trial, von Bülow lost, and he brought in a very good defense team, and after looking at the case and studying it and doing getting some juror advice from that, they decided that one of the things they wanted to do from this consulting firm was not to put him on the stand to testify. He had testified in the first trial, and they had decided that his German, he was actually Dutch, but his what sounded to be, to maybe many people, a German accent was likely to, cause the people on the trial to be biased against him. And so they wouldn't allow him to testify at the trial, although he's otherwise competent. There's some people who you might want to have as witnesses in their own defense. So for instance, there was a black professor who was accused of a crime out in California involving black rights. So she was accused of being part of a black terrorist organization that was going around robbing banks, and she was defending herself. And the lawyers decided to allow her to actually handle the trial, that they thought that she could do a very good job of representing herself, and she handled the trial and she won. But then there are people that you don't want to testify at all. So for instance, I had a client who was charged of burglary, and I didn't want him taking the stand, because if he took the stand, the prosecution could then introduce into evidence the unrelated, irrelevant, immaterial evidence of the fact that he had committed previous robberies and burglaries. And so he had been a three-time loser, if you would. And but this was not going to be made available to them, except if he testified, then it would be admissible into the case. And so I told him he couldn't take the stand, that at the beginning of the trial he should stand up and say that he is not guilty, and that would be the extent of his testimony, which of course is a normal thing that you usually start off a case. You have to stand up at the beginning of the case and make your plea statement as to how you plead. The judge will ask, so how do you plead? So this jury selection is a very important start of the trial, and I used to go and help some of my friends with their jury selection, because I told them about how I'd read all about these statistics, and I knew all these statistics on who would be a good juror and who wasn't being a good juror from the studies that others had done. And so some of my friends would call me in. And I remember going to a trial with one of my friends, and he basically had a trial in which he was accused of attacking a band with a knife, and you know, he was actually trying to get them to move their stuff and move their truck out of the way so he could get his wife to the hospital, who was having her baby, and they wouldn't move the truck until they loaded their equipment. They were taking too long, so he was accused of attacking them. And we had a number of jurors. My friend wanted to eliminate a certain juror, and I said, no, don't remove her. She had been previously raped. I said, well, rape is usually oftentimes committed by a group of men against one woman, and therefore she might see this man as defending his wife and might be a favorable juror. We won that case, much to our surprise, but there were other factors in it. For one thing, the prosecution was not able to produce the weapon, and they had overcharged him. They could have charged him with simply a battery or assault and battery, but they instead chose to charge him with criminal assault and battery, which needed to prove that he had a weapon. They never did prove that he had a weapon. Anyway, so summary judgment. There are two kinds of summary judgment. One is a full summary judgment in which the court says, well, there's no way that the other side can win this case. So usually, oftentimes in cases where insurance companies have to pay, the insurance lawyers usually apply for a summary judgment, and then you have to show that you can prove your allegations in your complaint with what kind of evidence you have. So you'll have to state what your evidence is that you're going to produce, and then the judge can decide whether that evidence is sufficient to prove your case. So I don't know of any case that I had that really turned on anything like this, but I remember reading in law school a case involving a claim that the plane wrecked because of birds flying into the engine, and that was the defense, and that defense was thrown out on summary judgment on account of the judge saying that he didn't believe that was possible for these birds on the runway to fly into the engine and cause the plane to go down. And so that was backed up by testimony, actually. Anyway, so summary judgment, you usually have to convince the court that one or the other side cannot make its case, cannot prove its case, that its evidence is not credible somehow, and cannot prove its case under any sort of facts, even if the jury believes the facts alleged, that the case cannot be proven by to the satisfaction of that. And so the judge, and of course that's appealable, so the judge you can appeal that summary judgment. There's also a partial summary judgment in which the damages can be limited. So the judge may, let's go back to the guy having been hit in the jaw. Was it $100,000? Now, I'd say, well, gee, that's a lot of money for a punch in the jaw. Well, broken jaw, on the other hand, is probably a serious operation. So you're going to have to maybe present evidence that to repair that jaw, he'll wind up having to pay, or his insurance company will wind up paying all this money. Also, you can make a claim for the pain that he suffers from having his jaw broken, which is a very painful kind of thing. So if the judge decides that the most he could possibly recover is $50,000, then you'll be limited to that. Again, that would be an appealable kind of thing. So the judge will look at the evidence that you're going to produce, which may include maybe testimony from people who know about these things, doctors who maybe can state what it costs to have a jaw like that and how much pain is involved. All this might be subject to testimony at the summary judgment hearing. So summary judgment is also there. And after summary judgment, you would then have the trial itself. And at trial, each side gets to call their witnesses. The prosecution will have to go first, has the burden of proof, and in a tort trial, the burden would be proving not beyond a reasonable doubt, but would be proving that it's more probable than not that the injury that occurred to the plaintiff was the result of the battery or the wrongful conduct, which was the battery committed by the plaintiff. And so he would have to put on evidence to that regard. And typically it would it might be the testimony of the plaintiff himself, but also if he has witnesses, that would obviously help if he had other witnesses to corroborate the testimony of the plaintiff. And so he will put on his evidence to that effect. So he will call the plaintiff to the stand. The plaintiff will testify. Before that happens, it's likely that the plaintiff's attorney will go over his testimony with him, and he can't coach him, he can't tell him what to say, but he'll try to tell him how best to say it. So he'll try to help him make himself clear and force him, basically get the ideal across that you should say your case confidently. You shouldn't say, well, I think it's this. You shouldn't hesitate. You shouldn't stammer and stutter. You should testify forcefully and definitely. In some cases, a defendant might be told it's okay to show sorrow. So if you were representing a defendant who was accused of murdering his wife, it would be very appropriate to tell him that he should actually show some remorse in the trial. Otherwise, the juror might think he's heartless and doesn't care about his wife. You can tell him to go ahead and release his feeling. You can't tell him to fake it. Okay? That would be coaching him, wouldn't it? But you can see there's a fine line there, right? So by your telling him that it's okay for him to show remorse and sorrow at the death of his wife, are you actually urging him to fake it? You would, of course, say no. I'm just telling him that it's okay for him to do it. And, you're telling him also that, if you don't, the jury is likely to think badly of you. It's okay for you to tell a defendant what to wear for court. So in divorce cases, it's not uncommon to tell women that they don't want to look too sexy at their divorce hearing. Okay, they want to look professional. It's a good idea for them to go out maybe and get a suit and not to look too attractive. You're not trying to convince the jurors that you're an attractive woman. You're trying to convince them that you're a wife who's being needing to now support herself, and you want some alimony from your husband. So that's not coaching. That's just telling them what they need to know in terms of testifying. Let's say you're representing a young man accused of rape, you probably want to tell him, if he comes from a rich family, not to dress up too rich. That is, go to Penny's, J.C. Penney's, and get one of the suits they got off the rack. And it may not fit you very well, all the better. You don't want to look like you're rich, because maybe that's going to help her get more money from you, or you're going to get less sympathy from them. So you can't coach them, but you can give them advice on how they should testify. And so these are just kind of things. Now, both sides in a case will typically appeal to emotions. Prosecutors will oftentimes wrap themselves in the flag. By that I mean they'll talk about how this person is degrading the quality of life here in America, and costing the state money by doing these kinds of behaviors. And so they'll kind of try to appeal people's civic sense, appealing to people's sense of civic duty. You have a duty as an American to put this man away because he's causing us problems. And the defendants may instead try to appeal to their sympathetic tone. So I had a client who was drunk when he was trying to gain entry into a hotel at 8 o'clock. No, it was 10 o'clock. Maybe it was 11 o'clock. It was after dark, he was trying to gain entry into a building that was a boarding house, and he was basically drunk at that time, and so my defense was that he was not really able to know what he was doing, but also, so that's one of the things you want to do. Intentional. So that's it. And so also another thing is that once the trial is, and so I also put on the stand his mother, who cried for the jury because he was not able to find a job. And so you usually want to make these kinds of emotional appeal to jurors because they are people, and of course you might not want to overdo it. And so it's a fine line that you draw on these kinds of things. And then the jury will go back and make deliberations and have to come, usually at common law you had to have a unanimous jury. Now some states allow for a majority of jurors to vote and get even conviction for minor things like drunkenness. But in other cases, oftentimes you need to get, if you got one person who opposes the case, you'll lose the case. And if the jury comes back and can't decide because one person won't agree with them, they can't get a consensus, you have what's called a hung jury, which case may mean another trial. And so at the end of the trial, you might have a retrial. So you can ask for a retrying of the case, or if you don't get a retrial from the judge, and the judge who held the case would be the one doing the retrial, and he would do that if he thought something was seriously wrong with the way the court had proceeded, the way the case had proceeded, that somebody had maybe misbehaved and maybe that they needed to do a new trial. You can ask for a retrial. Typically these are not given. Instead, you would have a right to at least one appeal. As far as appealing to the Supreme Court after you lose the first appeal, you typically won't be doing that. Only 5% of the cases get appealed, and of those, very few of those actually survive the appeal process, and so mostly you don't get appeals. So the Supreme Court will issue a certiorari if there's going to hear a case. So you apply for certiorari, and if they deny it, that's the end of the trial, and that's the end of the case. That's called final judgment, when all appeals have been exhausted. And up until then, there isn't any trial. So Ken Lay died before his appeal, while his appeal was pending, and so the judgment against him didn't stand, because that's the way the court has. The judgment's not good until it's the final judgment, until the last appeal has been heard. It's not that, and his last appeal wasn't heard because he died before that happened. And so the defendants in that case didn't get any money from that Enron defendant, who was to pay millions of dollars under the jury's verdict. So the jury makes the verdict, and the judge, however, still has to issue the final say, and so the judge on appeal has to issue that. So that's the end of that. Well, next week we will talk about intentional conduct. We're a little bit behind, but we will get through all this material, so we'll talk about intentional torts next time. Thank you very much.